Hi there, I'm Jim Zirin. Welcome back to More Conversations. If you turned on the news lately and seen a high-profile, powerful man accused of sexual misconduct or assault, which sadly seems to happen too regularly these days, chances are that the woman's lawyer is Gloria Allred, the powerhouse feminist advocate who has been a vanguard fighter for women's rights for over 40 years. Her clients, more often than not, include the raped, the abused, or the fired. The New York Times calls her the Avenger. An issue of Harper's Bazaar some years ago pictured her in armor as a modern-day Joan of Arc. Whether it is Bill Cosby, Michael Jackson, Eddie Murphy, O.J. Simpson, Donald Trump, or Tiger Woods, the list of men she has made her adversaries reads like a catalog of the rich and famous. It is not sexual activity in and of itself that Gloria Allred has opposed, but the abuse of power conferred by gender, fame, or wealth that she seeks to frustrate. Aptly called the master of the press conference, she typically wages her battles in the court of public opinion, often standing beside the client she defends, hand on her shoulder, representing the familiar image of the statue of blind justice, holding the scales or perhaps offering a tissue. Since the advent of the Me Too movement, Gloria Allred has been particularly active, speaking out, shaming the powerful, and never stopping, even at the door of the Oval Office. I am pleased to welcome Gloria Allred to this table. Gloria, really delighted to have you with us.
Thank you, Jim.
And you are perhaps the highest profile feminist lawyer in the country. Tell us a little bit about how you got started.
Well, I began my law practice 43 years ago, and we are the leading women's rights law firm, victims' rights law firm in the United States. And we believe that everyone should be treated with respect and dignity and afforded equal protection under the law. And that's what we decided to do. In the beginning, Jim, I didn't know any women's rights lawyers, but I felt that I was privileged and blessed to be able to become a lawyer because there were not many women lawyers in those days. And I felt that I had a duty to give back and that I should do at least a couple women's rights cases, namely sexual harassment in employment cases, civil rape, adult survivors of child sexual abuse, violence against women cases. At that time, I was doing family law as well. And, but then I became also president of the Los Angeles chapter of the National Organization for Women. And I started having cases sent to me, referred to me, and we began to develop expertise and interest in this area. And I was very fortunate that my partners, who had been my law school classmates and who came into practice with me, also began to have a feeling about these cases and that women were being denied their rights and we should help to assert those rights and fight for those rights and vindicate those rights in courts of law and elsewhere.
Well, is it any different now from the way it was 40 years ago? I think you said once that when you started practicing law, you never dreamed how much discrimination there would be in the workplace, how much sexual harassment.
Exactly. Because I thought, Jim, that some of what I had experienced as a woman was limited to me, that maybe I was in the wrong place at the wrong time, was bad luck.
So you yourself were the victim
of many kinds of injustices that women who came to me suffered. And so when they started coming to me as clients, I realized that sexual harassment in the workplace is severe, it is pervasive, that there are millions of women who suffer that in employment. Of course, sexual harassment is a form of sex discrimination under the law. And the reason we have laws against sex discrimination in employment is because we want to guarantee women and any victim, it could be a man who is sexually harassed as well, equal employment opportunity. If they are being sexually harassed on the job, that is a denial of equal employment opportunity. That's why it's wrong. It has, the victim suffers economic harm, often emotional harm, sometimes physical harm as well, and we need to stop it.
Well, we're seeing nowadays a spate of cases involving artists people of great talent, people perhaps of genius. I mean, quickly comes to mind Woody Allen or Kevin Spacey, and you have this issue with R. Kelly. And we see that some of these people are losing their livelihood, losing their occupation, being disgraced. Are we tending too much to sort of mush together the creator and the creation, the artistic output, and the undoubted talent of these people? Isn't that an injustice? Don't you see that as an injustice?
Well, I think there are two courts. There's one, the court of public opinion, and then there's the court of law. Certainly with the internet, there are no more gatekeepers, like the New York Times and the LA Times. Anyone can go on the internet, make an allegation which may or may not be true, that they have been raped, or that they've been sexually assaulted, or that they've been the victim of child sexual abuse, or any other crime. But of course, the accused also has an ability on the internet to respond in the marketplace of ideas on the internet and say, I didn't do it, I'm falsely accused, or whatever it is they choose to say, or not say anything at all. So there is no due process on the internet. For many of the alleged victims who go on the internet, it's too late for them to have access to a court of law because of the statute of limitations. Statute of limitations, as you and I both know as lawyers, is an arbitrary time period set by law during which a person who alleges she or he is a victim must file a lawsuit or assert a claim or report to law enforcement. It's different time limit, time period for criminal cases than it is for civil cases. Different if a person alleges she is an adult survivor of child sexual abuse, or if she is an adult victim of adult abuse. So, and it's different in every state as well. But the point is, for many persons who allege they are victims, it's too late for them to have access to a court of law. But there is no statute of limitations on the internet. There is no time limit during which they either must say something or be forever barred, as they might be in a court of law. It's not too late. So they can say it there. And often they've held this secret within them for so long, and they just want to get it out. And they also feel, and I've had many, many people who contact me for legal advice say, well, I want to help other women because other women may have also experienced the same thing, or may be at risk of that perpetrator still or again hurting another woman. And I want to help to stop that. So I'm going to say that. I want to say it on the internet. Now, as a lawyer, I don't tell them to speak out publicly, and I don't tell them to be silent. I give them the benefits and the risks of every option they have, legal options, non-legal options. Then they can make that informed decision about the best way to proceed.
Well, in the early years of your practice, certainly there was a reluctance among women to come forward with a complaint. It was embarrassing. It was perhaps shameful. There were many psychological reasons why any human being would want to avoid this area. I mean, sexual events are events that are classically conducted in private, and a lot of people feel they want to keep them private. Do you find
and especially the sexual predators want to keep it private and in the dark?
Certainly the predators, but do you find that since the Me Too movement, more women have come forward, more women are interested in suing, more women are interested in standing beside Gloria Allred at a press conference where they announce their grievance against someone who is a celebrity and is well known?
Well, again, since I've been doing this for more than 4 decades, I've also had women speaking out for more than 4 decades. It didn't start with the hashtag #MeToo. But yes, more and more have come forward, they're not willing to suffer in silence, many women anymore. They want to speak what they say is their truth. Because suffering in silence means that for many of them, they've taken that rage, that anger they feel about having been preyed upon, they've turned it inward. Turning it inward can be very unhealthy. It can lead to depression. It can lead to alcoholism. It can lead to using controlled substances, drugs. It can be very, very destructive emotionally. So what I like them to do is, rather than trying to tranquilize themselves out of their rage or not feel their rage, I want them to keep hold of that rage, which is a source of energy, but turn it outward into positive, constructive action.
Well, you've had at least 2 cases involving Donald Trump. Did your clients make an informed decision in those cases?
They did. They always make informed decisions.
And I think one case involved Summer Zervos, whom you no longer represent.
That's correct.
But she sued Trump for libel.
Yeah, and that case is still continuing with my co-counsel. And we survived their motion to dismiss the case. And so we think that's a very important case, and it is continuing. And at some point, probably very soon, President Trump is going to have to appear for his deposition, testify under oath to tell the truth, the whole truth, nothing but the truth, so help him God. And of course, we all know, given what his record is in reference to telling the truth, we can all make a decision about what we think he might say, whether he will tell the truth or not.
Now, Zervos' case is a defamation case,
yes,
where she alleged she was defamed because Trump called her a liar and denied that any sexual transaction occurred between them.
Well, it was more than calling her a liar. And so I won't repeat the statements that he made, but certainly it was more than just saying she was a liar.
Well,
and so he is going to have to be accountable. No man is above the law. I said that when we filed the lawsuit. It's still true today. Truth matters. And that's why this lawsuit was filed.
Well, do you find it somewhat ironic that during the campaign, he tried to expand the liability of the media, of the press, and by saying the libel laws were unfair and that public officials weren't allowed to sue for libel? But in your case, he did just the opposite, didn't he? He said because he was a public official, he was entitled to say anything he wanted to about your client. Is it somewhat ironic that he took both positions?
Well, there's a great deal of irony about about the person in the Oval Office, and but all I can say is he's going to have to be accountable, like anybody is, because the Supreme Court decided long before Trump became President Trump that that even if someone is president, that they are accountable for unofficial acts. And unofficial acts committed prior to their becoming president, such as in a tort, such as defamation, if that can be proven, is an unofficial act, libel or slander. And that was during the campaign. It was prior to his becoming president. So
that he allegedly defamed Summer Zervos.
Well, that's why the lawsuit was filed. It's the only lawsuit by any woman who alleged that he had sexually assaulted her, prior to his becoming president.
You had a number of clients who complained about Trump's conduct before he took office, but she was the only one to sue.
She's the only one that filed a lawsuit.
Do you find that most of these cases result in a lawsuit?
Not necessarily. No one is compelled to file a lawsuit. And the question is, and people have a lot of complicated issues in their lives. And so some people choose to do it, some people don't. For some people, there are lots of issues involved as to why they don't. But it does not mean that what they said had a lack of merit or did have merit. It just means they didn't file a lawsuit.
And do you find that when they do file a lawsuit that most of the cases go to trial?
Well, as we both know as lawyers, both in the criminal arena and also in the area of civil cases, most civil cases end in a settlement at some point prior to the commencement of a trial. Most criminal cases do not go to trial. They end in a plea, which is a form of settlement. So that's just the nature of all cases, because if all cases, criminal and civil, went to trial, there would not be enough courtrooms, there would not be enough judges, the whole system would break down. It would be impossible.
Do you try these cases yourself if they are tried?
It depends on the case. But we have a team in our office, a wonderful trial team. One of my partners just a few months ago, Nathan Goldberg, won a $4 million verdict. And that was breach of contract, but it was an employment case of actually a television on-air talent who was terminated from his contract. And we have discrimination cases. It really depends on what the case is. But we also do a lot of what we call pre-litigation settlements, confidential settlements, prior to even filing a lawsuit, or there is no need for a lawsuit if there's been a settlement prior to the commencement of a lawsuit.
Do you take depositions yourself?
Sometimes, but rarely. I mean, we have a team. I have wonderful partners. My two founding partners, Nathan Goldberg and Mike Morocco, who were my law school classmates, who were wonderful to go into practice with me. You know, they value my time, and they just, you know, they make recommendations to me as to what role I should play in any case. And they don't want me to play a role that someone else could do as well or better. And, you know, I'm coming in at a certain point in cases where we think it'll be of the most value to a client to maximize the value of her case.
Now, you had another case involving Trump, which was a Miss Universe case involving a transgender person who wanted to be a Miss Universe contestant.
Yes, President Trump knows me well, especially from that case. There's a kind of a photo, a shot of that case in my Netflix documentary, Seeing Allred. But what that really is about is, although I had met then Mr. Trump occasionally over the years at social occasions, we really had an encounter when a young woman named Jenna Talikova came to me. Jenna was a beautiful young woman. She'd always wanted to be in the Miss Universe, Miss Canada pageant. She lived in Canada. And she entered. And at some point, someone made an anonymous call to the pageant and alleged that Jenna had been born with a penis. Well, at that point, she was terminated. She lost her place in the pageant because they had a rule that you had to be a naturally born woman. Well, Mr. Trump at the time owned the Miss Universe, Miss Canada pageant. And Jenna was very upset that she'd been basically cut off, thrown out of the pageant. So she contacted me. She then flew down to Los Angeles. We had a standing room only press conference. And by the way, that's still on my page, gloriaallred.com. Anyone can go and click videos and statements and scroll back to 2012, and they'll see the whole press conference and Jenna's statement and mine. And in any event, at the press conference, I said to Mr. Trump something to the effect of, Mr. Trump.
He wasn't there, you just.
No, I said it publicly, but I know he heard it. Mr. Trump, we don't care what your anatomy looked like when you were born. You shouldn't care what Jenna's anatomy looked like when she was born. Well, the next day, and we want you to put her back in the pageant. We want you to eliminate the rule that you have to be a naturally born female to be eligible. The next day, Mr. Trump went on TMZ with Harvey Levin, and Harvey asked him, what do you think of what Gloria said? What's your response? And Mr. Trump said something to the effect of, oh, Gloria would probably love to see what's under my pants. Well, the next day I responded to Mr. Trump publicly, and I said, Mr. Trump, I don't have a magnifying glass that strong to see something that small.
Boy, don't tangle with Gloria Allred.
Well, that's it. And then, you know, we were off and running. Barbara Walters got involved. She flew us to New York. She interviewed Donald Trump. She interviewed me. And then as I was sitting there and the cameras were rolling, Barbara said to me, Gloria, I just came from interviewing Donald. And he said, I didn't realize the name of her client was Jenna Talikova. And then he wrote this on a white piece of paper, which she held up. And it said, Jenna with a G, Jenna Tull. What do you say to that, Gloria? So I said, Mr. Trump, this case is not about penises. This case is about discrimination by a business on account of the fact that someone is transgender. And this is about exclusion from a business opportunity, which is what a pageant is, solely on account of her status as a transgender woman. So I said, you know, the world does not evolve around or revolve around your penis or anybody else's. If it ever did, those days are over.
Amen.
This is about the law. Well, in any event, we won in the sense that he put her back in the pageant, he eliminated the rule, and of course then he said, oh, well, it wasn't because of Gloria, I was going to do it anyway. So we were happy to have that victory.
Proclaiming total victory.
As he always does, after, obviously, is that a complete coincidence? It's like after I got involved and went public. So in any event, I was very proud of Jenna and her courage. And today, someone just, when I mean today, I mean I think just recently in the last couple months, someone who's transgender won the whole Miss Universe contest. So we have come a long way, and we have in terms of trying to make headroads into discrimination against people who are transgender. I can't say we've come a long way having elected Donald Trump to the presidency, however. That's kind of taking us back.
Now, you've also had, in addition to sex discrimination and gender discrimination cases, you've had race discrimination cases. Tell us the one about the African American woman who had difficulty buying hair products.
That's a fascinating case. I'm so glad you brought that up, Jim, because some people think, well, days of racial discrimination are gone. That's in the past. But it is very current. We have a lawsuit pending right now against Wall-Mart, who is the largest retailer in the United States. It's on behalf of our client, Essie Grundy, who is an African-American mother of 5 children. And she also has a job outside of taking care of 5 children. Of course, taking care of 5 children is a job in and of itself. But she went into her local Wal-Mart, which is in California, and she went to buy some skin lotion, which is very popular with many African-American women. She went over to where the beauty products were, and she found that all of the products for both African-American women and men were behind a locked glass shelf. But she looked at the products, beauty products for other races. They were on open shelves. But what she had to do is she had to find a salesperson who had a key, who would then unlock that locked glass shelf, take out the skin lotion, not give it to her, but walk her over to the counter to pay while the salesperson still held the lotion. And only after she paid would Essie Grundy be handed the skin lotion.
What explanation could they possibly have for that?
Higher risk of theft, higher risk
They think
of
there's
loss.
higher risk of theft from an African-American woman.
Well, for the products of African Americans. She then also went to a different Walmart and to purchase a 49-cent comb, which was also often used by African Americans. Again, it was behind another locked glass shelf. She was smart enough to video all of this, so she has evidence.
But it's a risky product and they're losing money. Why don't they just discontinue selling it?
Well, we say they should either have all products for beauty products behind locked shelves, locked glass cases, or none.
As though they were gold watches.
Or none. But the point is, this is perpetuating a stereotype that African Americans, who are mainly the ones who purchase these products, are potential thieves, are potential criminals. Essie Grundy, my client, has no criminal history whatsoever. She would never think of stealing anything. And it's a stereotype. We think it violates our law in California, what we call our Unruh Civil Rights Act, which prohibits businesses from discriminating on account of race. We have overcome a motion to dismiss. We are continuing to litigate this case. Others now have filed as well. And we're looking forward to a successful result on this very, very important case. And we're very proud of our client that she's had the courage to bring it.
Now, you did all this, Gloria, most of the time during your years of practice as a single mother. Was it difficult raising a daughter as a single mother at the same time that you had such a demanding career?
Well, I've always worked outside the home. When I was a single mom, I worked, I was a full-time teacher in Philadelphia. I commuted twice a week to NYU. here in New York to earn a master's degree, and then 2 other nights a week I taught at the Cerebral Palsy Foundation. When I was in my 20s, I just knew that I had to do what I had to do to survive and make a better life for myself and my daughter. And then I moved to California. I married. I went to law school. I remarried, I should say. I went to law school, and then I became an attorney. So
Taught
look,
public school in Watts for a while.
I did.
What do you see as your legacy? That's my question for you today.
My legacy is that I fought for equal rights for all of us. And, you know, I'm just so proud of the courage of those who have not had their rights. We want to help to provide power to the powerless, voice to the voiceless, and rights to those who have been denied those rights. And this is how we have true equal protection under the law.
And redress the abuse of the powerful.
Yes, make them accountable.
Make them accountable.
This is the reckoning.
Okay, Gloria Allred, thank you so much for coming by.
Thank you,
And
Jim.
thank you for coming by. This has been just delightful.
Thank you.
Tune in next week for more conversations. I'm Jim Zirin. Take care and all the best. Now.